Well, thank you for having me, and I'd just like to echo Mike's comments about paying respects to the traditional owners of the land on which we meet and their emerging and future leaders. And thank you for having me. It's great to be here. I know this is probably not as exciting as sort of working out where the next sedimentary supergiant deposit might be in Australia, but hopefully the stuff that we'll talk about today will possibly help you find it. And so it's important that, we talk about those sort of things so that you can hopefully understand what your position is and what your rights are sort of under the new Act as we go forward. I'm going to be, you probably know, No, that's not working, but that's all right. I'll just use that.
Okay.
Working now? Okay. You probably know, I won't dwell on this, that the new Act has been really in discussion for 5 years, and it came into effect on 1 July, and you probably heard there was a lot of hoo-ha about it. And I think, as exploration and miners, we've probably got a better feel for it because we've been living with it longer than other segments of the community. But it has caused, a fair bit of, uncertainty. And I think the way the government rolled it out at the end, they sort of ran out of time and couldn't really get a lot of the details in place that they'd hoped. So it has been difficult, but it is in place now. We have to work with it, and that's really, what I help companies do. You probably know a little bit, and perhaps the only comment to make here is just about the national oversight as well. There is sort of post-Yukon Gorge, there was a Senate inquiry, and that inquiry sort of essentially found that the West Australian regime was really inadequate, and they recommended sort of a national oversight. And I sort of thought that was probably politicians, being politicians, and that it would probably fall away. But there does seem to be a little bit of momentum around this protection of cultural heritage, and now we've got the voice and things like that. It is interesting to see whether that gets any further legs, because it is, clearly a concern. We don't want to have national oversight to what we're doing, so we potentially got to comply with, 2 sets of rules. So, that's an interesting thing to watch. I suppose, why does it matter? This is a, pretty crucial thing. We all want our projects to run smoothly. We all recognise the need to meet shareholders' requirements, boards, market windows, all of those things. We need to get things done, essentially. So, really understanding how you can use these rules to your advantage is important. And, rather than sort of, just saying it's all too hard and giving up, there is a way to get through. And I suppose if I could leave you with one thing today, it is that, while there are uncertainties and there are challenges, things can get done, and things will get done, and things must get done, because, exploration and mining is critical to this state. The government doesn't want to stop it. I think they've probably created some issues that they perhaps didn't intend, but things will go on, and they can go on. So there are challenges, there are sensitivities and issues, but we have to push on. You will have seen and know that there's a significant company director liabilities now. So it's not enough to sort of ignore those things. You really need to be aware of what that means, and we'll touch a bit more on that later. Risk management, clearly, with your on-ground activities, due diligence assessments, which is something that we'll talk about as well in some more detail. Social license would be, a very familiar concept to all of the people in this room. And I suppose one of the really key things is about being able to establish a defence. So, if you think about this a little bit like safety, with safety, you put people out, in harm's way. You want to make sure that you've got good policies, good ways of doing things, and you've got procedures, because if you don't have those things and someone gets hurt, then you're in the gun. So this is now a little bit like that. There's much more process. You need to document your process, and go through those steps to make sure that at the end of the day, if you do harm heritage, then you've got a defence to say, well, I did my best. So I suppose some of the major changes, a big tenet of the Act is about early engagement and making sure that there is agreement making and consultation. So the idea really of the Act is to try and put Aboriginal heritage into the hands of traditional owners on the basis that it's their heritage. They should own it and manage it. So in terms of miners and explorers, a lot of you would have been doing that anyway. You would have been engaging and coming up with agreements and doing heritage surveys. So it's not totally foreign to you, but it's now, I would say, in the old days, you could probably not have an agreement, do a survey, and life would go on. Now a lot of groups are saying, no agreement, no survey, no work. So that's certainly what the government intends. They want consultation so that good decisions get made and that type of thing. Process for getting on the ground is obviously now very different. A lot of you would have heard about the tiered activity system, and we'll talk a little bit about that going forward, because that's an area, it's a really hot topic, and there is sort of some confusion in that, and that's certainly one of the areas that we're spending a lot of time talking with our clients. Concepts of permits and cultural heritage management plans to manage heritage, due diligence assessments, and the onus is on every individual. Every individual is responsible for ensuring that they don't harm heritage. So, whether you're a solo person, a big company, a junior explorer, you've got to take on that responsibility to do those checks. We've touched on the offences and penalties, and that's really quite significant, because previously there really wasn't any real consequences, and now as you probably heard, companies sort of $10 million fines, directors $1 million, for blatant harm, 5 years in jail for an individual. So there's been a few notable examples in the past where usually from smaller players, and usually not listed companies, but individuals who've gone out and done things, and in the Kimberley, for example, and they would be well and truly in the hairs under this sort of legislation. And I think the good thing about the people in this room is that there is always a care to try and do the right thing and protect heritage. So I think a lot of companies are very well onto that. They just want to understand how to get through it, because at the end of the day, the reason they're in business is to find things or develop them into successful businesses. That's why we do what we do. So there's a point there too that I just wanted to touch on, and it's no contracting out. It's kind of a legal point, but you might remember with Yukon Gorge, one of the issues was that Rio Tinto in their agreements had what's called a gag clause, and that meant that the traditional owners couldn't go and sort of effectively say, we've got a problem here, we're putting our hand up. So that meant that they put this provision in about no contracting out, which means you can't go and sort of contract out of your obligations on the Act. Of course, it also works to the benefit of explorers and miners, in the sense that if you're potentially agreeing to a higher standard in an agreement, then arguably you shouldn't be held to that standard, because you've got an Act, you've got a standard in the Act which says that you can't contract out of your obligation. So it's an interesting point to bear in mind when you're thinking about your agreements and your arrangements, just to bear that in mind. I mean, a lot of the traditional owner groups don't like to think about that clause, and we have conversations with them when we're arguing the point or putting the point or trying to make the point. So I think that'll be an interesting one as we go forward, to sort of see because as you can imagine, there are some old agreements that are probably well below the standard. We're seeing now that a lot of groups are trying to set a standard higher than the Act. So, you've got to sort of try and think about what that gap looks like. So processes for getting on the ground, one of the really key points, and I think it's really quite sort of topical, when we think about the broader picture of what's going on in the Act, is this concept of the due diligence assessment. So the onus is on every person before they go out and do something to work out whether they're likely to harm heritage. And really, once you do that due diligence process and you go through the steps in the Act, it's going to spit out an answer where you're either pretty sure there's no risk, you might be operating in previously disturbed areas, there's no registered sites, perhaps there's been surveys, and you're pretty comfortable with the outcome. Maybe you're not sure, or maybe there is heritage, and depending on those outcomes, that really shapes the way you think about what you can do, and think about how you need to engage with different groups. Am I doing a drilling program or a soil sampling program? What's the risk around harming heritage in those situations? So, they're the kind of practical issues that people need to be thinking of. And I think that's been a little bit lost in the conversations that have been having. And I think there's this perception that, we can't go and move 4 kilos of dirt because, we might harm heritage, and no one ever does a soil sampling program, with 4 kilos. So, but the thing that gets missed in that conversation is that you can only not move, more than 4 kilos of sample if you're going to harm heritage. So the only way you can determine whether you're going to harm heritage is go out and do this due diligence assessment. So, that's something that we're doing a lot of to try and help our clients just get through that process to be able to make an informed decision. So you'll know about the tiers, the exempt activities. So these are things like walking around and taking photographs and stuff. The tier 1 activities require a sort of a simple due diligence assessment to work out what you're going to, whether there's a risk of harming heritage. Tier 2, sort of auger drilling and more ground disturbing sort of activities, and that sort of level, you're into sort of a more extensive DD assessment, and you might need a permit if you're going to harm heritage for a tier 2 activity. For a tier 3 activity, so you're going to go and do some drilling, and there's a risk that you're going to harm heritage because you're interacting with a site or whatever, then you're really going to go and need to consult with the traditional owners and come up with an Aboriginal Cultural Heritage Management Plan. And so there's a template, a rough template that you can use, but each one will be different because it'll depend on the facts. I'm going to take questions at the end too, and I'll be around a bit afterwards. So if people have sort of specific questions, feel free to talk about it. So here are sort of some of I suppose the activities that we talked about. Travelling on existing roads is a big one. That can sometimes be an area that causes a bit of confusion. It's pretty important to know, what your position is there. The other thing to think about is, am I operating within an exclusive native title area, a non-exclusive native title area, or a claim? If you're operating in an exclusive native title area, then, the traditional owners have got, more say to say you can't come in. But you might also want to check whether those roads are actually included in the determination or not, because often major roads, good example would be the Canning Stock route. I mean, that goes through some pretty serious native title areas, but that's a road that can be used either with permit or freely. And, we do sometimes see in our discussions that groups try to sort of, control the use of roads. So that's an important one to think about. Aerial surveying is another one. That's a good thing in the sense that that's it's a tier 1 activity, so you don't need to go and you need to minimise your risk of harm, but you don't need to go and consult or seek approval. Now, I mean, you might not want to fly over a registered site or whatever, but as a general principle, that's not included. So, thinking really about handheld equipment is probably the broad sort of threshold there. Tier 2, we talked about air core drilling. If you're creating a new track, removing between 4Ks and 20Ks of material, and yeah, sort of really that non-held thing. The material, I know the 4Ks and the 20Ks has caused, there's been a lot of talk in the industry about what that actually means. And I suppose the short answer is, as I touched on earlier, is that you want to try and assess what your program is to see what activity tier you fall into. So if you're going to do a soil sampling program, in the ordinary course, you're going to be moving more than 4Ks, but it's per sample, right? Seems to be the prevailing view. So if you're going to do that sample, you do your due diligence assessment, and you work out that the area that you want to do your 200 samples, which is clearly more than 4 kilos, 20 kilos, or whatever, it's going to be a big number. If you can establish that there's no risk of harming heritage in that area, then you're okay. But if you determine that you want to go and take some soil samplings within a registered site or within an area where you've been told that there's heritage or something like that, then that's where the 4Ks. So if you take less than 4Ks, you're in a tier 1 activity. As soon as you go over 4Ks and you're between 4 and 20, you're in a tier 2 activity. So that's where you would ordinarily need to go and get a permit. And if you're taking over 20Ks, then that's where you push up into a plan, an Aboriginal Cultural Heritage Management Plan, and you would need to go and consult and do all that. So I guess the obvious question is, if you were doing a soil sampling program, I mean, most geologists and companies I know would say, well, we'll just avoid that area if we know it's there. And, obviously if we go and soil sample around it and it turns out that there's an enormous, deposit there and we need to go and talk to the group about harming heritage, well, we'll go and have that conversation. So I think that's a sort of a practical thing to keep in mind when you're working that out. But you can only work that out once you've done your due diligence assessment. And so we're seeing a lot of that with our clients. So they come and go, look, I want to do this. There's been surveys here. We've got an agreement here. Can we do it or not? So that's sort of, how to be thinking about it. Tier 3, I think most of you would be pretty familiar with those kind of things and things that you would expect to see. I think we had an interesting situation a couple of weeks ago where a group was essentially cleaning up a track to prepare for a survey. So it was an existing track. They were just tidying it up for the vehicle to go through. Archaeological consultants went out and had a look at it and had seen that there was a few areas where there'd been some fill moved to fill in, a creek washout, that kind of thing. And, they'd flagged that because technically they'd gone outside the footprint of the track. So that's kind of, that's, I think, an issue that a lot of you would be familiar with, where you're either clearing a track or touching up a track. Just, bear in mind, try and keep your people, give them clear instructions, and we'll come to some of the things you can do with your policies and procedures to make sure that you're managing that risk, because at the end of the day, the risk is on the ground. So, I think we've all probably seen, bulldozer drivers who love making tracks, and you want them to do one that big and you come back and it's that big. So these are some of the things you need to start thinking about to really manage that risk. So this is a little bit more talking about that, conducting that due diligence assessment that I talked about. So the onus is on the proponent. the company, the individual, whoever's doing the work. You know, there's a management code which sets out the steps that you need to take to work your way through that due diligence assessment. And there's now an online portal called Acknowledge, which is sort of the way in the future that you will sort of interact and deal with things like putting in permits and plans, and it'll timestamp your submissions so that your, you know, the time periods under the Act sort of get regulated. Now, it seems to be a bit of a work in progress from what I can determine. My sort of playing around with it in the early stages, but you know, the idea is that surveys will be on there, all of the LARCs will be on there, all of the contact details that you need. So it'll become your, you know, a central repository of information. But, you know, it seems to me that the challenge is going to be, how is that ever going to be complete? You know, the existing register is probably got 30% of the sites on it. And that's the challenge in, you know, part of this process. The challenge is, well, for a tier 1 activity, it says you go and look at the register, and you look at the register, and if the register is 30% complete, it doesn't give you a lot of comfort that you can then go and rely on that. So, you know, something to bear in mind. So the first thing you need to do is confirm you're not in the protected area. There's about 80 protected areas in the state, and I reckon there'll be some more, you know, start to emerge. I think groups will start sort of trying to use that mechanism to probably protect certain areas. Confirm, you know, whether the activity is exempt or what the tier is. Assess, you know, whether there's heritage in the area, what's the risk of harm, and then, you know, depending on what the outcome is, you've got to then, you know, consult, or you can go ahead and do your activity. So this point here is that, you know, even if there's no risk of harm, when you're on the ground, you've got to, you know, there's a positive obligation to take all reasonable steps to, you know, to protect, you know, that risk. So, and again, that's all part of creating this defence. And so, you know, what that means for you guys in the real world is that, you know, when you're operating on the ground, you've got to have policies, procedures, and, you know, ways to make sure that you can show that you've taken all the steps that you need. So that's why, you know, record keeping and documenting the things that you're doing becomes, you know, really important. This is a really important concept that I'm sure a lot of you would have heard of, but this concept of like for like. So one of the, it's a really important point for explorers and miners, because what it effectively says is that if you're operating in an area that has already been disturbed and you're doing an activity that is the same, then you're exempt. So that might be, you might have a mine site and you might have an existing mining footprint, and you're not going outside that mining footprint, and you're, you know, restarting operations. That's an exempt activity from a heritage point of view, putting aside your native title obligations from a heritage point of view in terms of your operations. Alternatively, if you're going out into a heavily disturbed area, it's been drilled, and you want to go out and drill some deeper holes, or you want to twin those holes, and you can sort of show that that area has been disturbed and there's no risk by doing a due diligence assessment, then you can go out and do that activity that's exempt. So again, this sort of question about farmers, it's come up, you know, if you're in a paddock and you, you know, use that paddock for 20 years and grown food in it, you know, you should be exempt. Now, there's sort of the challenges, I guess, are around the edges and fringes of that, where, you know, you go out and you clear a new pad and it's not quite in the right area, or whatever it might be, but that's the principle. So, you know, it's a really important concept for, you know, just, you know, there's a lot of areas that are unfinished business in exploration, and there's a lot of areas that have had a lot of holes in them and a lot of work in them. And so it's just an important thing to think about as to, if you're going into an area that has been disturbed, can I rely on the like for like to give me some comfort, or at least some leverage in a conversation, you know, with some traditional owners who might be, you know, sort of pushing back on that. I won't really touch on this. There is a process for agreement impasse. So this is kind of like, if you think about the old Section 18 process, there's a new process, and it's a lot more structured than the previous process. But ultimately, you might recall a few years ago when the Act passed in 2021, a lot of the Aboriginal groups were very upset because there'd been a late change where the minister had the final say. That previously he didn't, and then he did. So that ultimately is still the process. So for those of you who do need to go down that process and you can't get a resolution through a cultural heritage management plan, as long as you've engaged in good faith and you've negotiated properly, there is a mechanism to go through to get an answer if you ultimately do have to harm heritage. And I suppose that's why it's important to document things, and that's why it's important when you think about that issue that I touched on before about contracting out in your agreements. If you have kind of given away your rights under the agreement because you've agreed something in the contract that's a higher standard, well, that's an argument that you might have to have. You might win it, but you might have to have an argument. One of the other areas that is important is the related agreements. So that's your existing heritage agreements. So what's the status of those? Where do they sit? They can be used as sort of evidence. So if you've done heritage surveys or you've done work under your heritage agreements, they can be used as evidence of engagement or a cultural heritage management plan if you need it. So if you have to try and harm heritage or have that conversation, you can use those related agreements as evidence to satisfy either a due diligence assessment or a plan. So it's probably it's a little bit of a grey area, I think, because as we said, all agreements are different. Some of them are more modern, some of them are very old, some of them just are not going to cut the mustard. And so, really it's a bit of an assessment about how your agreement sits in relation to the new Act, and it probably depends on what surveys you've had done and how old the agreement is. I've just put this slide up, which essentially just takes all the words in the Act and tries to put it on a slide to show how the liability in the Act sits. And I suppose the simple way to think about it is that the person on the ground who was to, if that person was to damage the heritage, they're potentially liable. The contractor who employed them is potentially liable. The company is potentially liable, who might be the client, if it's a contractor or a drilling contractor, and the directors and the board, under the Corps Act would potentially be liable. So the liability, I guess, flows all the way through, whether you're an employee, a contractor, all the way back up to the top. So now, in reality, it's probably not going to be the employee who they go after. It's going to be the person with the deepest pockets. So I guess that's important to understand and just appreciate, from a liability point of view, how that works. So, it's the responsibility of all individuals. An employer can be liable even if an employee acts without the employer's authority, which I find a pretty difficult one to get my head around. But I suppose the answer to that is that you just need to make sure that you've got mechanisms in your agreements and in the way that you work to try and mitigate that risk. Because at the end of the day, if someone goes rogue and does something they shouldn't do, then you just want to say, well, I've done everything I could. And, it comes down to, again, having a defence. So that's the way I would practically think about that. And again, you've got to take all reasonable steps. So what the principal or the employer knew or ought to have known about the risk and whether due diligence could have prevented the contravention. So again, this is where you come back to the due diligence assessment, and I've got it on file. I made an effort to try and understand what my position was, and I acted on that, and at least that gives boards some comfort that they can either decide to accept the risk or you know, will say, I want more information, I'll go and do some more inquiries, or I'll put my, you know, my campaign off for a period. So I think, look, it's not all doom and gloom there, because you'll see there that you've got the defences. So, you know, the reasonable steps you can take in the due diligence assessment in terms of your employees and your people. Education and training, you know, is obviously key. You know, your policies and procedures, how do you do things on the ground? What happens if you find something, you know, stop work, all of those kind of things, so that, you know, you've thought about it and you've got some of that stuff in place. And then thinking about your standard contract clauses, you know, how do they look? There is just a point worth making on that slide. You'll see in the middle there to the right, there's a comment about JV partners and JV agreements. So for those of you who might be in joint venture agreements, you might be a silent partner and someone's earned in and they're off doing stuff, you're potentially liable as well for their actions. So you need to make sure that they understand about this stuff, and that they've got policies and procedures, because, you know, for example, if you're the more financial partner, they could potentially, you know, if there was an issue, they could potentially come back to you. So, you know, think about that in your joint venture clauses and your deals going forward, because, you know, it's an issue. So look, just touching very briefly on this, and I think we have talked about them. You know, we've talked about contracts and making sure, you know, your contractual terms with the people who are doing work with you, that you've thought about where that risk is. Now, again, you can't contract out of your responsibility, so you can't sort of, if you were a mining company, you can't just push it all onto your drilling company under a contract. But at least if you've had a conversation about it, or you've, you know, tried to incorporate something to indemnify yourself or to do something, then you've got a little bit more protection than if you hadn't even thought about it. So, you know, the other thing there is compliance with company processes and procedures. So, you know, what are your operating procedures on the ground? Do they have their own? Do they operate under yours? How does that all hang together? Employees and agents, we've talked about managing that risk. I think, you know, another emerging kind of trend and issue will be D&O insurance. So, you know, with directors and being liable now, I think we'll start to see that flow through to D&O policies. It's not something that generally gets thought about now. I don't think insurers are really thinking about it, but I suspect that if you don't have some of these policies and procedures in place, you know, apart from, you know, obvious ESG type requirements, I think, you know, premiums will probably go up. So I think it's, you know, worth thinking about that. So this is just a little bit of a slide on some of the things that we're seeing now in the market. You know, doing this sort of every day. You know, as you know, there's a broader definition of Aboriginal cultural heritage. So that means landscapes, you know, things that are aesthetic in value. You know, it's much broader now than just things in the ground. So, you know, I expect that definition, that's going to get tested, and, you know, particularly with the ethnographic sort of areas. So, you know, where there are areas that traditional owners really don't want people to go to, I suspect we're going to start seeing a bit more of the ethnographic thing coming up. I think, you know, we've seen some agreements where groups are sort of cherry picking a little bit on bits of the Act that sort of probably favour them. So that's kind of interesting, you know, the activity tier language, because, you know, one of the really important things I sort of think, particularly in exploration, given the risk profile, when you step out onto land, you don't know what you've got, and you know, you're faced with this position where, you know, you've got to potentially spend hundreds of thousands of dollars to work out whether you've even got something to go with. So I know that that's an issue that causes a lot of grief for smaller companies, because they just can't even get on the ground. So, you know, that's something that, you know, look, is a real issue particularly at the survey point now. And I know that some of you would be seeing some sort of fairly big survey bills once you get through the agreement, and that's an area that we're certainly spending a fair bit of time trying to recalibrate, shall I say, some of those conversations in a way that preserves the relationship, because at the end of the day, this work is really, it's a combination of the law, but it's also the relationship. And I suppose that's one of the things that we try and do and bring is, we've got pretty good relationships on the other side, where in most places where we can have a reasonably frank conversation and a constructive conversation about what should happen. And for example, whether a track should be required to be surveyed if it's exempt, and some of those kind of things. So they're all the things that I think you really need to be thinking about. We are seeing percentage of expenditure clauses, which typically were the domain of the Kimberley and probably East and Western Australia, sort of starting to come into places like Meekatharra and the Ashburton. So that's probably that again, that becomes a bit of an impost for exploration. But what we are typically doing, or what we can often do, is we'll agree a fixed number, because at least that gives you an opportunity to go in and find out whether you've got something, and then if you've got something, you can have another conversation. So we think, and I think this is the way you should be thinking about it, is trying to align your activities with with the risk of what you're doing, and just trying to get a commercial outcome that gets you to a certain point. And then once you get to that point, you then have some idea whether you've actually got something that's prospective or not. And it's much easier to have a different conversation when you've actually got some money behind you. And that's obviously one of the big difference between explorers and miners. And I think a challenge that the bigger miners have created for the smaller guys in terms of expectation and what it looks like. So I think there's more oversight coming as well. So we're seeing, like perhaps after a survey, they want to go and do another inspection, sort of to monitor works and things like that. That's I think a bit of a challenging situation when you've just gone and done a survey. There's also this concept in the Act about Aboriginal inspectors, and they can go out and look at work. So that's probably another thing. I mean, DMIRS has probably always been too under-resourced to ever go out and inspect a lot of things, and it's going to be interesting to see how that goes, and whether there will be people who, so there will be more inspection of rehab and things like that to make sure that, things are getting fixed up. Exclusion zones, a lot of you would have seen and be familiar with those in agreements. And, often there's a situation, there's an unwillingness for groups to tell you up front where they are. And so, I wonder, and I think, sometimes, again, there's a risk that, areas sort of get sterilised from your tenement. And I suppose the thing you don't want to have in that situation is you go and pay a fair bit of money to get access to the tenement, and then your tenement gets sterilised. I mean, having said that, a lot of the groups that I regularly work with are reasonably good. I don't know if it's just the ones I work with, but, I know that it can be a mixed bag, but they're generally, trying to do the right thing, and they will try and work with you to only quarantine areas that they see as a risk. So, but I think certainly understanding when you're going to go and do something up front, whether there are exclusion zones is a good thing to know. We talked about contracting out, so I won't talk any further about that. So I think this is just a little bit of I suppose, a few thoughts on some of the things that you can be doing. Things are obviously going to take a bit longer. Groups are under-resourced. I think we all know that, and I don't think that's changed. And I think, but that's clearly a challenge with this new system, is that it is more detailed, regulation heavy. And I think, we're going to find some groups who just sort of put their head in the sand and keep going and doing what they're doing. And, depending on what you're doing and where you are, that might be something that you can work with. But engaging early, I think we now have 3 or 4 LARCs that have sort of come forward. So the LARCs are the groups who will actually be the point of contact for any heritage surveys that you do. So that's supposedly a one-stop shop, which in principle is good because it means you can sort of avoid that situation where you don't quite know who you should be talking to and those sort of challenges. So I think that's a good thing. Make sure you're really thinking about your timeframes for what you want to do. And I understand there's lots of drivers like the market and different commodities and obviously shareholders' expectations and share prices and that sort of thing. So really sort of sitting down and mapping out what you want to do with your exploration and working back from there in terms of, well, who do I need to talk to? How long is it going to take? Is this group a difficult group to deal with, or are they an easier group to deal with? Because, as many of you would know, it's, some groups are far harder than others to deal with. Become familiar with the management code. So that really sets out the concepts I talked about around due diligence, what the activities are, what are the activities that you're looking to do, and sort of the key documents, because they're the key documents that help you get on the ground. Think about educating your employees, and things like that. I mean, we're doing a reasonable amount of that kind of work, just helping miners get ready and having policies and procedures and that kind of thing to ensure that they can feel comfortable once they do step onto the ground. So there's sort of some of the things that that we do as well. Helping, really helping through, I suppose, that due diligence assessment process, because we've had sort of a reasonable amount of feedback from people that there's a lot of people sitting on their hands going, well, I don't want to do anything, and I don't really think that that's the right way or the necessary way to think about it. I think there is a way through, and I think at the end of the day, this state is built on mining and exploration, and if people are not exploring, then we're not finding things, and that's not what the government wants. So there are, as I said, there are sort of challenges, and it is much more detailed and nuanced than it was. And there is, of course, the relationship side of things that is nuanced and sensitive as well. And you always need to keep that strategic objective in mind about where you're trying to get to and what your outcomes are, and whether you're prepared to push a soil sampling program, for example, because it gives you some data that you need, but you can't afford to spend 300 grand on the survey because that's what has been asked. So that there's all of those kind of issues to think about, and I think it comes from an overriding place of people wanting to do the right thing, people wanting to build good relationships with the people, the country that they work on, because there's a huge amount of richness that comes from those those good relationships, and they have good knowledge, and they can help and learn about the country that you're working on. So that's just a bad photo of me. But we essentially, a bit about us. My background is sort of in legal and corporate, and I've sort of been involved in this particular space, but also, corporate and M&A and all of those sort of things. So worked in junior explorers and miners and have a fairly good idea of what the buttons are. And I suppose, I've come to this native title and heritage area, particularly in the last sort of 3 or 4 years, because I think there's a big need to help, the industry get on and do things, because, it's just really important. So, we do that. We do transactions. We help companies that are developing projects, with their operating contracts. We bring a fairly sort of commercial and pragmatic lens to the way we think about it. And the other thing we do, I suppose, the big part on the Aboriginal side is a lot of the relationship side. So it's about more than just, it's not a legal solution, it's a total solution to get you to the end, which includes building a sustainable relationship with the group. Because if you can create that value proposition, for them. You know, a lot of them want the business. You know, most of the traditional owners that I deal with, probably with few exceptions, are open for business. So, you know, they're wanting to talk, and so it's about trying to get there in a way that that works. So that's really all I have for you. I know it's very much a scratch of the surface sort of presentation, but hopefully it gives you a little bit of a sense, or perhaps fills in a couple of gaps, because I know that, you know, it's a pretty educated room. But look, you know, I think overall, I think, you know, find a way through. You know, use it as a strategic advantage. And you know, for those companies, I've got some clients who are operating in areas where people are walking away. And, you know, it creates a very good opportunity for them, because they're prepared to engage and, you know, come up with a way of dealing. So, you know, I suspect some people will probably recoil and say it's all too hard, but I think, you know, I think there is a way through. And you just need to, you know, you need to invest the time, and, you know, and there is, you know, there is opportunity.